Well, I want to thank the setting sun for bringing Oren Lyons and Tom here. Oren, back in 1986, we formed the Alliance of American Indian Leaders. And
hey, Joel, you have to step back and you just introduce yourself first for the,
okay.
For the video. Yeah, then go into that. Okay, thanks.
Okay, my name is Jewel James. My Indian name is Sasiah, from the Lummi Indian Nation. Back in the 1980s, there was a group called the Alliance of American Indian Leaders that formed. And it was the late Roger Jourdain, late Wendell Chino, late Joe De La Cruz, late Sam Kagi, late Art Gabeau, late Larry Kinley, late Kelsey Edmo. And I don't know if Richard Reelbird's alive or not, but I know Dale Riesling and Ron Allen is. Ron was the young tribal leader that came on board at that time, and I was just a staffer for Larry Kinley. And the Alliance had organized a meeting of themselves with the National Indian Health Board, and they brought Oren Lyons in to teach us about Indians and the Constitution and prophecy of the Iroquois Confederacy and how it influenced America's form of popular sovereignty. And it was a real powerful moment, and for me, it became a life-changing moment. And Oren said that when you pick up those teachings, that you become a wolf runner. And I took that to heart because he brought in his elder and we planted a sacred tree, a tree of peace ceremony on the mall. And so that bound me spiritually to the teachings. And then later on, Roger Jourdain, he brought out the pipe, and he also had a ceremony. He bound us all to the teachings. And so we couldn't just walk away if we believed in the spirituality. And so I took it to heart. And over the years, I used this to battle for the treaty rights exemption. It was one of the primary motivators I had on the Constitution and treaties made. And so it was the main argument that I'd use in lobbying the U.S. Congress, and we organized our campaign to get Indian fishing rights exemptions. And now it's law. 78-73 is the Indian fishing rights exemption. When we did that, we had the third most powerful man on the Hill fighting us. He said there's no way that this, and he quoted, this chicken shit Indian language is going through. And of course, Lummi burned boats, and we kept on going. And we battled them and we won. Later on, we did the interpretation so that all 16/16 of the fishing rights pie is totally tax exempt. It's the only Indian resource industry in the United States that is so broadly interpreted that all parts of it is tax exempt, and the United States government and the state governments cannot tax any part of it. So that was a major victory. And over the years, based on Oren's teachings on the Indians and the Constitution, I would always hit the IRS wherever they'd go, and I'd bring it up that you're in violation of the United States Constitution. And I'd cite the laws. Article 1, Section 2, Clause 3, excluding Indians not taxed. Article 1, Section 8, Clause 3, Indian commerce. Article 1, Section 2, Clause 3, excluding Indians not taxed. Article 2, Section 2, Clause 2, treaty negotiation powers. Article 3, Section 2, Clause 1, the courts can interpret the treaties made. Article 6, Clause 2, treaties of supreme law of the land. Article 6, Clause 3, all officials, state and federal, are bound by those treaties of supreme law of the land. On the Fifth Amendment, when they amended the U.S. Constitution, they made sure that tribal Indians, now this is a real key distinction, tribal Indians cannot be represented, cannot be a member of We the People, and cannot be taxed. And so the Reconstruction Congress in the 1860s after the Civil War made sure that language was in there. Section 1 of the 14th Amendment said subject to the jurisdiction thereof. When they asked what that meant, it meant if you want a relationship with an Indian tribe, you have to negotiate a treaty. If you want a commercial relationship, then it's authorized under the Indian Commerce Clause. Other than that, Indians are outside the Constitution, and the tribal Indians owe their allegiance to their tribe first and foremost. So John Elk later on, 1884, from Omaha Nation, took a test case on. He went all the way to Supreme Court, and they said, John Elk, you're a tribal Indian. You cannot be one of us under the United States Constitution. You owe your allegiance to your tribe. If we want relationships with you, we'll enter treaties or regulate commerce with you. And so John Elk lost. He was classified as a tribal Indian. But during this time, from 1872 on, the United States developed what they call the Religious Crimes Code. And so the Navajos, the Sioux, the Northwest Indians, all across the United States Indians would go to jail for talking their language, doing a song, dance, or ceremony. And that lasted until 1924, when a woman named Ida Mae Adams, a lawyer, took on the Indian rights and said, let's give them First Amendment under religious freedom under the U.S. Constitution. And so the United States enacted that act in 24 on two reasons. One, American Indian religious freedom under the First Amendment. Two, in honor of the veterans that served in World War I. And so from 1924 to 1978, we did not have religious freedom. So we had to get the American Indian Religious Freedom Act. In 1988, the United States struck it down so it doesn't protect any sacred sites or places. In the night, we lost eagle feathers. We lost the right to peyote in the Native American church, which is over 10,000 years old. Prisoners lost the rights to rituals. Thanks to Reuben Snake and Oren Lyons and others that became a part of the Religious Freedom Project, in the 1990s, we got all those court cases overturned, and you got the American Indian Religious Freedom Act amended. Okay, but still, in 1956, the tax court took a case against the Quinaults, and Capone went in to defend his rights. Now, during this time, the tribes couldn't defend him. They weren't allowed into court. It was between the United States and a citizen Indian. They said, you're made a citizen in 1924. So it's between us and a citizen. It has nothing to do with tribal rights. And so they kept the tribes out. We were so busy fighting termination, trying to stop relocation, trying to stop them from sending in states under Public Law 280, that we didn't have the effort and we didn't have the authority to hire our own lawyers and to be in a tax court and to defend our people. BIA controlled everything, and we're considered incompetent. And so tribes were set up for the loss in 1956, but Capone defended 1/16 of the industry, the rights of his own, because he owned the timber on trust land, he got trust income. But all 15/16 of the rest of the industry became taxable. Now the court said in ordinary affairs, Indians are citizens. And so we have to, we never got that defined. The IRS just came in and said, all you Indians are citizens. And they never distinguished between an ordinary affairs versus tribal Indian owing allegiance to your tribal nation, doing tribal activities within your Indian country. And so it's been a battle because the IRS goes after individuals. And usually they can't afford to pay the taxes, the penalties, or the interest, or the fines, and so they settle. And so it's a lot of cheap victory that has built up the precedents. Now, part of our problem was that in Oren Lyons' teachings, these are the parts of the Constitution that stops them from having jurisdiction over Indian tribes. If they live by the Constitution, and then these cases up on top that support tribal government and treaty rights, government-to-government relationships, these cases, they're not that clear, but they support sovereignty, okay? And not as clear as if it was our inherent sovereignty, our traditional inherent sovereignty, but this is a sovereignty that's interpreted through white eyes, white law, white judges. And so they're recognizing some of it. Okay, down here, these are the cases that say Indians are incompetent, non-competent, and we can do as we please. Basically, they're saying there are no rights the Indians have that we have to respect. And so this undermines not only our government, but our status as tribal Indians. And so on this side here, where it says treaties interpreted as we understood them, ambiguities resolved in our favor, absent changes by treaty or statute, then Indian sovereignty is intact. Down here, the basic tenet is U.S. guardianship over nations and individual Indians as wards. And so in Johnson B. McIntosh, I know Oren and many others have gone across the United States, Tom up in Canada, talking against the Discovery Doctrine. The Discovery Doctrine was a way that discovering European nations who discovered our land and discovered us, the first Christian nation to discover us had first claim to the territory. But really the only claim they had was to establish relationships with us. But then the Catholic Church says, oh, unless they're infidels, pagans, heathens, atheists, and then you have the obligation to conquer them. And so under that, those papal bulls, the Pope was supporting these Christian nations. Now this during the time of Reformation as well, so while discovery is going on, they're competing amongst countries in regards to how to reform the churches, so that not everybody's a Catholic, but they're still Christians. But we're considered as non-Christian. Now in Johnson v. McIntosh, what was going on here is way before 1823, almost 70 years earlier, colonialists came into Indian country and he said, "Want to buy your land." And so King George says on the proclamation of King George, "Stay out of Indian country. Only I can establish relationships." And so that case went on and it got developed. It was a rigged case. It was basically the same party on both sides suing itself. But Marshall, Chief Justice Marshall, took the case. Him and his dad had applied for 258,000 acres inside Indian country. And just so happens, by coincidence, the decision he made guaranteed him and his dad got all that land. Okay? And he did feel bad, so he said in Worcester, the state of Georgia has to stay out of Cherokee Territory. But later on, he would say Indians are dependent domestic sovereigns, like wards to the guardian. And so he structured this schizophrenia. This is, there's two personalities in Indian country. And if they were not schizophrenic, and then the U.S. Constitution would keep them out, just as Oren has taught us in 1986, it would limit their jurisdiction inside our boundaries, and they would regulate commerce with us. If they wanted to change that relationship, it'd have to be by treaty. And so without that schizophrenia, these cases would have been more strong pro-sovereign. And so what I recognize based on Oren's teaching is that most lawyers that are defending Indian country don't know. They don't know the original relationship, and that is still alive under the Constitution. It's still valid under the Constitution. It's never been amended to stop or change this check and balance system that was written in. And thank God for the Iroquois Confederacy. And later they added the Choctaw Confederacies, that they were major influences on the evolution of popular sovereignty. And so I'm really happy as a wolf runner to be able to finally report to you, because it's been 86, 96, 2006, 32 years that you put me on this journey. And with those ceremonies between you, your elder and Roger Jourdain, I was tied to this truth, advocate this truth in all the battles. And so Walter Eckelhawk wrote a book on In the Courts of the Conqueror. And I said, "Darn, Walter, that's a good book, I'll read it again." So I read it again, and I thought, "Why didn't you map it out, Walter?" And I go, "Why don't I map it out?" You know, so I mapped this out, and so far where we presented, the idea was that eventually this would be a computerized system for all tribal leaders to be able to track these teachings versus these teachings, and to know the difference. And so due to budget constraints, I wasn't able to get out there, but I know NIGA would be willing to. Ernie Stevens said, we'll raise all the funds for it. You know, John Eckelhawk, NARF says, we need this. We want to be a party to it. And so the basic idea is to hand it off to John, see if they want to take it further. But the thing about this whole campaign is that now we're dealing with taxation. And so I know most leaders don't understand that. Excluding Indians not taxed, like you taught us, is still valid law. It's still a part of the 14th Amendment. And the 1924 Act does not amend the U.S. Constitution. And so we are still tribal Indians. They said, what are excluding Indians not taxed? Those are the tribal Indians. They're outside of our jurisdiction. We do not have dominion or jurisdiction over them. And so we still exist, but in 1940, a solicitor issued an opinion, and he tracked all this information. It looked like he's going to say, the Indians are right. They're separate from us. It looked like it. He put all that evidence in there, and then he said, but you made them citizens, so there no longer exist any tribal Indians. So by a stroke of a pen, all tribal Indians across the nation disappeared politically and legally. And so we became these incompetent, taxable citizen Indians. And so my argument is that in ordinary affairs, that's one where if we're going to be a U.S. citizen under this 24 Act, in ordinary affairs, when we're out there living with them, walking with them, talking with them, worshiping with them, doing everything like them, voting for their government, and then that's in ordinary affairs. But when we come home, our allegiance is to our people, and our tribal nation governs over us and protects us. That's tribal Indian. That's what the tribal Indian expects. That's under the sovereignty of the Indian nation. And so over the years, we have battled for these different definitions of what is not taxable. This stuff down here is the tribal Indian rights. You can't touch this. And we're slowly expanding it over time. As a tribal Indian, we have rights under the Indian Self-Determination Act, the Self-Government Amendments, the American Indian Graves Protection Repatriation Act, American Indian Religious Freedom Act, the American Indian Arts and Crafts Act. All these different laws that are enacted are specific to tribal Indians. Only tribal Indians can do that. You can't be a citizen and do this. This is limited to Indian country. And so if you're a non-Indian trying to do this, you're going to get sued and you're going to get stopped and you're going to get driven out of Indian country. And so especially like the American Indian Arts and Crafts Act that we just got amended a few years ago. Above this line is the areas that we say in ordinary affairs Indians are citizens. And so if you're out here in the city, Seattle or San Francisco or Chicago or New York, and then yeah, you could be out there as a taxable Indian. But our challenge is to differentiate between in ordinary affairs, Indian citizenship, tribal Indian status, and ceremonial activities. If we ever get, the test case I set up by fighting for the exclusion of all Indian totem pole art, all Indian art as tax exempt, well, I just won this week. The idea was to create enough ambiguity in the IRS's understanding that it may have to go back to Congress. And then that's where we come in. And then where we get the definitions that we need on what is a tribal Indian, like John L., the court already defined it in 1884, and it's still a standing case. And what are Indian citizens? And what are, in regards to their duties to the state or federal government, and what are tribal Indians in regards to their duties to tribal governments? And what are ceremonial activities? Well, in my presentation that I handed you the literature on what I hope becomes the booklet on ceremonial activities, it's all of this. Wherever our traditional knowledge and our traditional song, dance, and ceremonies, all of that handed down from generation to generation, are ceremonial activities, because we're reciting to our children how to live in a way with the world around us that was taught to us by our ancestors. And so even though we wanted to, my case became an example, they already ordered the Seattle office to stop auditing Indian artists. It's under ceremonial activity. And so that's in place now, and they're processing the paperwork, but it's not national yet. Our goal is to get them to the table and to keep fighting based on this relationship, the constitutional relationship, the treaty relationship, the government-to-government relationship. We demand consultation. Like in the United Nations Declaration of Rights of Indigenous Peoples, free and prior informed consent. And so we got to exercise that and demand the consultations. And some are saying, oh, it's too late. You should have done that in 2015. You know, hey, we resisted for 500 years and we're going to be here for another 500 years resisting. Whatever it takes. You know, and if we are successful, then hopefully we'll undermine the foundations of Squire versus Capone, where they've got to step back and say, oh, wait, the court said in ordinary affairs. And we should have limited it to things outside of Indian country. And so Rudy Reiser said in 1986 in front of the House hearings dealing with the Arizona's Republic's news article that the BIA was stealing everything, which Cobell proved. Well, Rudy testified that you appropriate $1 billion for Indian country, for Indian affairs, but you take out $4 billion in taxes. Okay, they take out 4 times more than they allocate. You know, so the other things that are down here, of course, is Indian health, treaty rights, and housing and stuff. And so those are exercised as tribal Indians within our Indian country. And so the whole plan is to keep being a wolf runner for you. Here at Lummi, they don't know I became a runner for your nation, that you gave me that. And I think in all, one thing I can say is that it guided me in everything we've done on this side. I kept it alive. So this was my opportunity to finally report to you and let you know that I heard you, and I put it right here, and I'll keep it there. And thank you for being who you are, because I remember You and the chairwoman of Geronimo's people. She was chairwoman of Geronimo's Apaches. I forget her name right now.
Names are hard for me now.
Yeah, but she was born in captivity. And between the two of you, we heard the message of survival. And so the alliance is gone, but I think their message is alive. And we do have the standing resolutions, House Senate Concurrent Resolution 76 and House Concurrent Resolution 331, that said America's form of constitutional government is based on the teachings of the Iroquois and Choctaw Confederacies. And the relationship is by treaty and government to government. So thank you for being a teacher.
Well, it's amazing what you've done. It's amazing. You're a very analytical mind, and that's what you have to deal with them. And I would say this is the, what you've laid out here is a history. And we haven't really fought the fight yet. I mean, it's been in and out of the course now, but little by little, we've been backing them up because of this kind of work. And the battle for sovereignty is coming. It's not, this would be the groundwork of it.
Yeah.
But it's coming. But it's up to the people to do it. I mean, you know, you can talk about law and so forth, but if the people don't back it up and don't get in the fight, then you can't, you're not gonna go anywhere.
Yeah.
So the foundation is build that spirit in the people to battle. They're gonna take things away. You know, that's how they'll deal with it. But you have to get past that and stay the course, you know.
Yep.
And I would say the next 10 years for global warming is going to make a lot of definitions, no matter who you are, no matter what your law is, no matter.
Yeah.
It's going to bring a common survival, and they may have to go back to our values to survive.
Yeah.
And so it's not over at all. But this kind of work is really important, very important. So we've got it laid out, and we have to put that in some kind of a context that we can refer to, and they can refer to, because you're dealing with them on their level of law.
Yeah.
But with the principle in the back behind it, that's the strength back there.